Well, hello everyone. Welcome to this first in our series of lectures on litigation in court cases and education law. This is part of a longer series, You and the Law, in your new career as teachers. I've got the Supremes playing in the background here. So you can see that it's a different group of Supremes than the people dressed in little costumes there. They're the judges of the Supreme Court of Canada, but they are indeed the Supremes, and we will become familiar with the Supremes throughout this cast. So without further ado, I thought I would begin by talking in this introductory lecture about education law, just generally, some of the ideas around your responsibilities as teachers, your duty of care towards your students, how you stand what's called in loco parentis, or in place of the parent, in a school context, those sorts of things, what teacher negligence is, in relation to duty of care, things like this, and we'll look at some court cases that deal with those issues. So to begin then, education law is a kind of complex critter. It's made up of, there's statutes, right? So there are, basic laws that govern education, and in earlier lectures in this series we've looked at some of those laws, like the School Act, or the laws dealing with professional conduct of teachers, those sorts of things. There's also what's called common law, and what common law is, it's different than laws that are written down in the law books, right? Laws that legislatures make. A common law, what that is, that's something happens, there's a dispute, it's taken to court, and people go before a judge, and they present their case on this side and on the other side, and then the judge rules, right? The judge says, well, in this case, X, and this is, and then so the judge's rulings, or the judge's decisions, those become part of law too, and they stand as what's called precedent, right? So that means that something, say, might have happened back in the 1800s, for instance, right? And a judge may have made a ruling on a particular dispute, and then it's 2015, and you come to court, and then the lawyer cites something that happened back in 1800s, or say 1950 or something, and then they say, well, this is, given this sort of a situation, and this particular kind of law, this is typically, traditionally, commonly, or common law, right? This is commonly how things pan out in a law court. This is how other judges have traditionally, typically dealt with this exact or very similar sort of a circumstance, right? The idea behind common law is it gives some kind of regularity, or it predictability to what will happen. So common law is really, really important, right? If there was no consideration of common law, then really there'd be no precedent, and you would never know what a law meant. It could mean anything in the hands of this judge or this other judge. People would go judge shopping. I mean, this still happens, right? People shop between judges, and there's a lot of discretion given to judges, which can be in itself quite problematic. One judge can rule this way, one judge can rule a completely different way. You see that a lot in family law courts, when there's disputes, people fighting over children or custody or something like that, where they shop for judges. And so common law is a kind of a way of reining in, reining in the idea that this could go any which way possible. It's the idea that there's a sort of predictability that, whenever this sort of a thing happens, this is likely going to be the outcome of it in law, and then that gives you some direction as to how you can proceed as an educator or as a parent or whatever situation you find yourself in, right? So it's part of the law. Another thing, school board regulations, these are different than statutes, like statutes or laws or legislation made up by legislatures, right? School board regulations are made by school boards. So those aren't, a school board is a creation of the province, right? It's not itself an order of government. It's just a critter that the province made, and it can unmake as well, right? And those school boards are all made up of elected officials who work all together to make certain regulations for that particular school board. And different school boards have different sorts of regulations, but again, all those often are, well, they should be all recognize and follow the statutes that are in place in the provincial law books, right? But the idea behind allowing school boards to make their own regulations is because obviously, right? Like, if say you're a rural school board, you're going to have different needs, and your students are going to have different needs than, say, one in a huge city like Toronto or, say, Calgary. And so you should be able to make regulations that are more specific to the area of the world that you're living in, the kind of students that you have, those sorts of things, all right? So there's statutes, there's common law, there's school board regulations, and also there's collective agreements. And those are the things that, like when you're a public school teacher, everybody who works for a school board has to be part of a union, right? And so unions, they protect teachers, and they have a certain place in education to try to make education better too, right? But then collective agreements, you're also beholden to following whatever your union has bargained or agreed with the government. You, as a member of that union, have to abide in those things too. So, like, an example of that would be, every, I don't know, however many years it is, the collective agreements change. And so it may be that, at one time, say, when you started teaching, you were required to do so many hours of supervision, and now suddenly you find yourself in the new collective agreement having to do 1.5 times that. Whoa, that sucks. Well, but that's your collective agreement, right? Or suppose that your old collective agreement said that you were guaranteed to have a full prep every year. Well, your new collective agreement yanks that from you. Well, that sucks. Well, that's collective agreement. You have to abide in that, right? At the same time, your collective agreement protects you from having to do things that are not required of you as well, right? So, because lots of times, principals may, or school boards may, try to weasel, their way into getting you to do stuff that is way above and beyond already the crazy workload that you're going to have. So that's a different kind of thing. Oh, and in there too with union stuff, right? Like, don't forget, there's the code of conduct we also talked about. So, like, if ever there's any kind of say a dispute arises between you and one of your colleagues or something, there are certain dispute mechanisms that you have to follow in order to allow those things to proceed. So that's a different part of education law as well. So you can see education law is kind of a complex critter, right? Okay. What about the status of school boards in law? What are they? Well, I mentioned it briefly. School boards are a form of local government. They're corporate bodies created and uncreated by provincial laws. They are the vehicle that usually is used to deliver education, but they're not the only possible model. Alternative examples, we've talked about these in earlier lectures, like homeschooling, right? You can school your kids at home. There's also private schools, right? Private schools aren't part of a school board. And also there's charter schools. Charter schools, as we've already talked about, are public schools, but they're not part of a school board. They're organized and set up differently than that. So you can review our earlier lectures on that. And then school boards, it's important to remember, they don't have rights against the provincial governments other than the denominational protections in Section 93 of the Constitution Act. Again, I already did a lecture on Section 93 of the Constitution Act. Very important, the Canadian Constitution, or the BNA Act. But other than those denominational protections, realize that school boards can be made or unmade, right? A school board doesn't have any right to exist. It can be created. It can be just wiped out. It can be amalgamated with another one. It can be broken up into smaller chunks. Provinces can do whatever the hell they want with them, pretty much. And even funding for them too, right? Like whether it's they're allowed to levy taxes or these sorts of things. All these things, there's no necessary right for those things in law. Only in regards to denominational protections in Section 93 of the Constitution Act. Okay, next thing I want to discuss with you in this introduction to litigation in education law is this notion of the teacher as standing in loco parentis. That's different than Speedy Gonzalez, who says loco in the cabeza. What is in loco parentis? Well, this is a Latin term, and it means in place of a parent. Okay, it refers to the legal responsibility of a person or organization to take on some of the functions and responsibilities of a parent. It's originally derived from English common law, so it goes way back, and it's applied in two separate areas of law. First, it allows institutions such as colleges and schools to act in the best interests of the students as they see fit, although not allowing what would be considered violations of the students' civil liberties, right? Second, this doctrine can provide a non-biological parent to be given the legal rights and responsibilities of a biological parent if they have held themselves out as the parent. All right, so you act in place of a parent. Now, the concept that the teacher is acting in loco parentis means, in short, that the teacher stands in the position of a caring parent as an unofficial guardian. This concept not only allows the teacher some of the privileges of a parent, but also brings with it added responsibilities for the protection of pupils. Thus, a teacher could be liable for damage caused to a pupil where the teacher's conduct falls below the standard of care. We'll talk about that in a bit. Commonly accepted as being reasonable in a parent-child relationship. A teacher may even have to meet a higher standard of care where special knowledge makes the teacher aware of dangers that the normal parent might not appreciate. Okay, so teachers and school authorities, therefore, occupy a peculiar position in relation to children. They are at once in loco parentis to the students, and therefore act in a private capacity like their parents might, but they're also state officials. So that means we work for the man, right? And therefore, as servants of the state, we work in a public capacity. As such, our actions, our words, and our policies are all accountable to the Charter of Rights and Freedoms, which governs how Canadian citizens must be treated in relation to state action. Okay? So we have these two components where, in some way, like a private capacity, like parents towards our students, but then we're also, because we're public servants, we're working in a public capacity. So what does this mean? Well, the dual nature of our status towards our students, especially since the advent of the Charter, means that we aren't permitted the discretion we once had under the common law. Suppose, for instance, that a school board wants to enforce or uphold a notion of community standards that aligns with the expectations of the majority of parents within its jurisdiction. Say as in the Chamberlain v. Surrey School Board District number 36 case from 1998, where it sought to keep a number of same-sex themed books, children's books, out of the curricular readings in kindergarten and grade 1 classrooms, where the parents were from ethnic backgrounds and religious traditions in which such relations were not considered acceptable, right? So here you have local community standards, community expectations. You have, the private capacities of families and parents and people like this in a smaller community or in a place in, say, BC, where people have very traditional, we might say, conservative views on sexual orientation and other things like that, right? So, there's many things that you could read with your students in your class, say, that would not offend such parents. But you, as the teacher, feel it's important to school or to, read books that have to do with same-sex parents in your classroom with kindergarten kids or with grade 1 kids, right? But then, you're doing that, but you're also doing that, in a place where parents are not comfortable with that, right? So, should you? Should you? I mean, it's like kicking a hornet's nest, right? Are you cool with that? Are you cool with the backlash from that? Is that your place as an educator? To in some way, I mean, the parents might say it's a violation of their own right to raise their children with, say it's a religious belief, or say it's like a cultural belief that they harbor at home, right? Is it your place to interfere with that? Maybe it is, right? Maybe not everything is cool in Canada, right? Maybe certain religious or social, cultural practices, you got to let those go if you're going to live in Canada. And teachers are part and parcel of, teaching the younger generations about being good Canadian citizens who are open and respectful and the rest of it, right? But also maybe you should be just stepping back and say, well, parents really, they don't want me doing that. Maybe this is not the hill to die on. Maybe there's other things that I can read with the kids that are really great, but maybe don't step on what they consider, what they feel is their own ground, right? It's not my business. Those are professional decisions that you'd have to make. And this Chamberlain v. Surrey School District case was all about that, right? So, what I'm saying here is, our understanding of this has to change since the Charter. So this particular case, here the school board attempted to act in loco parentis, right, in the place of the parents. The local school board acted to honor the parental wishes of the parents in this particular school district, all right, regarding sex education of their own young children. All right, so they were acting kind of like to respect or honor the wishes of the parents, right or wrong. But as state actors, see, the school board's intentions here fell afoul of the Charter, Section 15.1, which prohibits discrimination against any person or persons on the basis of sexual orientation. So, turns out that the school board isn't allowed. Teacher wants to bring this in, right? Teacher wants to have these books in the class, thinks this is really good and important. Like, what if there's kids in the class whose mom or dad or mums or dads or whoever, that this is a situation. Like, and you're talking about family very often, the social studies curriculum in particular, especially in Alberta, right? It's one of the first things you learn about is me, my family, my local community. You want to see your own self reflected in the things that you're reading, right? So the teacher is concerned to do this, and this is one thing that he or she felt that was important. And turns out that in this particular case, the Supreme Court said, yeah, you're right. You should be allowed to have these books and read these with your kindergarten kids and your grade 1 kids. And too bad if the parents think that's no good. Now, next thing I want to talk about with you is teacher liability. So there's a great deal of interest in teacher liability at this time in history for 3 basic reasons. First, many school and off-campus activities are prone to accidents and therefore possible litigation. My wife and I were talking about this. We grew up in the 70s and 80s, and the things, kids would get injured at school, or not even at school, but during the summer. Maybe somebody's teeth would get knocked out by a baseball bat, or somebody would fall off a slide and injure themselves, or somebody would. Anyway, that was just the way it was, and folks back then, we weren't in Canada. It wasn't a thing that we did, go out and sue your neighbor, right, or attack them or bring them into court. And times have changed. Now, it seems that there's more and more people in Canada who think that this is the way that we solve our problems, is litigating and suing each other. And so this is a relatively new development, ladies and gentlemen. Many schools are concerned about this, right? In fact, I would say probably all the schools. The number of off-campus activities has increased dramatically in the past several years, thereby increasing the potential danger of an accident that could easily lead to allegations of teacher negligence. Second, in recent years, the courts in Canada have awarded large sums of money to students who were seriously and permanently injured during a school activity. So this is just, attractive, right? If you realize that, well, actually, if I do sue, I can make a boatload of money from an injury, it's just more enticement for more litigation, right? There's now a much greater incentive for parents whose children are injured at school to risk the high cost of litigation in the hope of obtaining a large compensation award. And third, the public understanding of the concept of rights and a corresponding readiness to seek redress or suing has increased. We're therefore faced with the likelihood of more litigation involving teachers. This section provides the ounce of prevention that may avoid a lawsuit by informing teachers of their liability. Okay, so we're just going to talk about teacher liability here. I've taken lots of this information right off the ATA website. If you're interested, you can find it there. So, teacher's duty of care. What does that mean, duty of care? Well, this goes back to England, actually, in the common law. And the Court of Appeal in England, in this old case, Williams v. Eadie, it's from 1893, they established that the duty of care owed by a teacher toward his or her pupil as the standard of care expected of a careful and prudent parent towards his or her own child. This is from Brown and Zucker, right? I'm getting this from their book. They note that this high standard of care continues to be influential in Canadian courts. So in Williams v. Eadie, the judge said the schoolmaster was bound to take such care of his boys as a careful father would take care of his boys, and there could not be a better definition of the duty of a schoolmaster. Then he was bound to take notice of the ordinary nature of the young boys, their tendency to do mischievous acts, and their propensity to meddle with anything that came in their way. Okay, so duty of care has to do with, what would a careful, prudent parent do in similar situation? That's what you're expected to do as a teacher. Now, that can be pretty tough, right? I got 3 kids. I don't know if you have any, but, as a teacher, you're going to have 36, sometimes now you can have 40 kids in a class. I don't know, they've changed the rules, all at once. So imagine having, it's like the little old lady who lived in the shoe or whatever, right? What kind of duty of care is there? Is it fair to suppose that, this idea of the parent, the careful, prudent parent, in today's classroom situation, is the same as it was back in 1893, when maybe you didn't have so many kids to look after, or maybe they were a little bit less rambunctious, and prone to, I guess, step out of line, as it were, right? I found this meme on Facebook, and I thought it was really funny. The 1970s, no knee pads, helmets, brakes. It's just how we rolled. Teachers must behave as would a reasonable parent. The degree of care required depends to a considerable extent upon the age of the pupil, and to some extent upon the particular susceptibilities of the individual pupil, which ought to be known to the teacher. Older pupils may self-evidently be exposed reasonably to greater risks than younger pupils, right? They're the littler kids, you know this, right? They're not aware of dangers in the way that maybe older kids are. However, the duty of care is not extinguished simply because the pupil has attained the adult age of 18. We'll look at a court case where the student was, legally an adult male, but he was 18 or older, but because he was in this school situation, there was a duty of care that was recognized that the teacher failed to abide by, and so the teacher was held negligent for what happened in that situation. Now, what's reasonable when you're a teacher with so many kids in your care? All right, so in seeking to equate the role of the reasonable and caring parent with that of the teacher, there are immediate difficulties, right? Parents don't have 25 or 30 children to control and supervise at any one time. Their children, when at school, are exposed as part of the education process to risks they would not face elsewhere. The home and school environments differ in so many respects that it's impossible to conceive of the role and responsibilities of the teacher as if he or she stood in the place of a parent, reasonable or otherwise, in relation to the child at school, right? I mean, that's one thing you might say, and I think there's a lot of sense to that, right? Nevertheless, that's what we're beholden to. This is why even back in 1968 in McKay v. Board of Govan School District 29, the Supreme Court of Canada recognized that it might not be fair to hold a schoolmaster to the same level of accountability as a parent who, after all, doesn't have a small army of children to watch, all at the same time. Nonetheless, the duty of care of the teacher remains, that it be exercised with prudence, and that it be reasonable remains a high expectation placed upon all educators. Okay? This is a big deal when you're a teacher, being held to this account, right, as in place of a parent. So, given that, there are various grounds for litigation where there is thought to be a failure in duty of care on your part. A teacher can run afoul of the law and fail to meet the standard of care in a number of ways. The typical claims launched against teachers and school boards that accuse them of failure in such duties include lack of adequate supervision, improper, inadequate, or defective equipment, failure to warn pupils of the danger or dangers of an activity, failure to train pupils in safety, failure to take reasonable precautions against injury or loss, failure to hire competent staff or train them properly, and failure to treat an injury. All right, so those are all different ways in which you can fail to meet the proper standard of care or duty of care. You can be held negligent in some fashion. It's important to note that the standard of care imposed on boards and teachers does not require them to take precautions against accidents that are unforeseeable. So just because, bad things happen, it doesn't mean that every friggin' thing that happens in your class or, in your school is somebody's fault. I mean, stuff happens, right? It's a big school. It's full of, probably 1,200 kids. When things happen, is it always somebody's fault? No. Okay? If it's unforeseeable, it's not predictable. Okay, so teacher negligence, what is that? I've taken this from the ATA website. Negligence comes under the broader heading of tort law. The word tort means crooked or twisted. Generally speaking, a tort is a wrong committed by one person against another. Some specific types of wrongs are assault, defamation, and negligence. Now, negligence consists of not doing something a prudent and reasonable parent would do, or doing something that a prudent and reasonable parent would not do. Okay, because it could mean, in other words, you do something or you fail to do something. It can be the subject of a lawsuit between persons whenever there is a duty upon one person not to be negligent, and when a breach of that duty occurs that causes damage to another person. Negligence exists where the activity or conduct on the part of the teacher creates an unreasonable chance of danger. I mean, there's always danger in life, right? I could go out to the mailbox today and, something could happen to me. There's just the way it is. But, what about, unreasonable danger, right? You put kids in situations where, they're apt, something is apt to happen. When teachers ignore the danger or do not see the danger when they should, they may be held negligent if someone is injured as a result. Well, the law recognizes different degrees of negligence too, folks. There is slight negligence, which is a failure to use great care. There's ordinary negligence, which is the failure to use reasonable care. And then there's gross negligence, which is failure to use any care at all. It should be understood that to warn a pupil of dangerous places and actions is not an adequate defense if a suit is brought for negligence. All right? So if you say that place is dangerous or this action's dangerous and that's all you say about it, and then something happens, it's not good enough. In law, you can't say, well, I told them it was dangerous. I mean, what else should you do? You say, well, it's dangerous because, or, if you do this, or if you go here, this might happen. This other thing might happen, right? So you have to give them more information about why, what to look for, what to watch out for, probably supervision in that case to make sure that things are, copacetic. It's not just good enough to just say, this is dangerous, watch out. Likewise, it's not sufficient to put up instructions regarding proper conduct to avoid such accidents. It's really good to have instructions and rules, right, in your classroom to keep people safe or to review them from time to time, but it's not sufficient, right? Such instructions are valuable from the standpoint of reducing accidents, but when one does occur, they do not remove liability for the teacher who has been otherwise negligent. Again, ATA finds 4 elements must be present before negligence is established. So, first, the plaintiff has suffered some damage. All right, so in order for any negligence to be found, first of all, somebody has to have gotten hurt. Second, the damage was caused by some act or omission of an act of the defendant. Third, the act or omission was one of which a reasonable person behaving with ordinary prudence would not have been guilty. All right, so somebody's gotten hurt, and if you had been on your game, that wouldn't have happened. If you had been conscientious, if you had been reasonable in your position, that wouldn't have happened. And 4, in the circumstances of the case, the defendant owes the plaintiff a duty to take care of that act or omission that was in breach. So there has to have been a relation of duty of care between you and that student. All right, so the extent to which the injured party contributed to that party's own damage would also be an issue in determining the amount of damage to be awarded. So in other words, like, say you're a shop teacher, right, and you've told the kids all, about the dangers of the shop class. You've given them instructions on how to use the equipment, how to be safe with the equipment, and yet still some kid sticks his hand in the machine. At a certain point, we have to say that the kid is responsible for what happens to him, right? You can't just say that everything is a teacher's fault. It's very often the case that students bear some responsibility for getting hurt at doing X, Y, or Z. Like, if I go out on my bike, I did this when I was in my 20s even, you go out on your bike, you go careening down a hill without a helmet, the hill is, uneven. I went ass over tea kettle and carved my back up and got all kinds of gravel in my arm and the rest of it. Whose fault is that, right? That's my fault. So, these sorts of things, it's a judge, in other words, would look at to what extent is it, are you responsible for the injury as the teacher? But then also, does he or she bear any responsibility for what happened? So the damages can be greater or lesser depending on, maybe it's 25% the student's fault, or maybe it's 50% the student's fault, or maybe it's 75% the student's fault, or maybe it's not the student's fault at all, or maybe it's all the student's fault, right? That will enter in here. So as with punishment, the principle of in loco parentis applies. So too does the idea that teachers who possess expert knowledge must exhibit a higher standard of care than ordinary parents in elements of the subject matter or programs that are inherently dangerous. This would apply to the use of chemicals, machinery, or apparatus, for example. So here's some court cases from Canada that are kind of interesting, all about duty of care litigation. The word litigation, what's that mean? That means when something happens and people go to court over it, right? They litigate. This party against this party go before a judge, and the judge makes a ruling. Okay, so good example of this sort of litigation is Myers v. Peel County Board of Education from 1981. In this case, a 15-year-old boy broke his neck attempting a straddle dismount from a gymnastics rings apparatus. No teacher was present, and the boy's spotter had moved away from the apparatus. And the judge found that a protective parent wouldn't be content with no supervision and with only a 2.5-inch thick mat on the floor, right? So, pretty clear example of negligence there, right? By the way, some of these court cases you're going to find them really, really depressing. And the point of this exercise of exposing you to some of this isn't to depress you or make you feel bad about education or or scared to be a teacher, that somebody's going to sue you or anything like that. It's just to inform you, to get you thinking about, what does it mean to be dutiful in your care towards your students. All right, keep that in mind. I don't mean these cases to turn you off of being a teacher, because it's a great career. Just be aware that whenever we're in the classroom with our students or supervising them in any capacity, let's always do our best to be careful and cautious. Realize that we're supposed to be looking out for them in their safety. Okay, another example is Thornton v. Prince George Board of Trustees of School District 57. This is 1975, this court case. The Supreme Court of Canada reviewed this case of a 15-year-old student who jumped off a vaulting box onto a springboard and attempted an aerial somersault. The student overshot the pit and landed on a thin mat, sustaining serious injuries. And the phys ed teacher was found liable, and the school board was found vicariously liable for the negligence of the instructor. So, in other words, not only can the phys ed teacher, who should have been, more vigilant in making sure that the students in his gym class were safe, not only can he be found liable here, but also the school board who hired this guy can be found vicariously liable. Like maybe, they should have trained this teacher better. Maybe he's a new teacher. Maybe, should he have been given some instruction, or should there be a school policy on safety and supervision in the school, right? Or what about the gym equipment, right? Like when the gym equipment is given over for physical education instruction, how adequate is it, right? Is it safe? If you're going to have a vault, if you're going to have a springboard, what kind of padding is there, right? Maybe the school only had the kind of padding it had, and that's why the phys ed teacher used it, right? Because it was the only stuff that was available. And maybe he figured, well, because this is what we have, then it must be okay. You know what I mean? So you can have vicarious liability in a school board for actions or failures of actions of the teacher. Here's another one from 1990. It's Thomas v. Hamilton Board of Education. This one, a grade 11 boy who was a good student athlete and well accomplished in sports. He executed a tackle, but accidentally hit an opponent the wrong way with his head down, and the boy's helmet wasn't sitting on his body right, so it was removed before putting him on a spinal board, and he got quick and expert medical attention after the accident, but he still unfortunately became a quadriplegic. All right, so he was injured in a football practice. Well, this distraught his parents. They sued the school and the teachers, saying he should have been warned about the dangers of football, and that he wasn't properly trained on how to tackle. And they said that he was allowed to play when he was tired, and that it was the school board's or the school's fault because he had what they called a long swan-like neck. Their son had this long neck, apparently, that they thought the school should have been worried about prior to the injury and not let him play a tackle position. So they came out, they were furious, right? I mean, they've just lost, their son has, this, can you, how horrible that would be to have that happen, right? To your baby. So they wanted to blame somebody, and they came after the school. And the court dismissed the parents' accusations here, though. I mean, they said, well, it's common knowledge that football is dangerous and rough, right? And the court found that the swan neck theory that the parents and their lawyer came up with didn't wash. And also found no evidence that the son was particularly fatigued before the accident or not in proper physical condition. And also they looked at the coaching staff, and they found that they'd complied with reasonable standards for junior high school football. And the parents had also signed one of these consent forms. You've seen these probably with your own students, or maybe when you were in school you can remember having to bring those home. And they'd even produced a medical certificate prior to him getting on the team that said he was fit to play. So really, the parents, they didn't have a leg to stand on in this. I mean, it's a terrible thing that happened. It's why this is kind of sucks talking about all this stuff. But you have to understand that, even in this kind of a situation, it's like a freak thing, right? People are going to be looking at you or looking at teachers and saying, you did this to my son, or you did this to my daughter, or this is your fault. All right? And then how does that pan out in school litigation? Here's another one, Bain v. Calgary Board of Education from 1994. And here we have that 19-year-old student I was talking about, right? Now, he was a special needs student, too, so that enters into it, I think. But he was injured on this hike. So he was in grade 11. He was a vocational student on a school-sponsored forestry tour. And the students were scheduled to watch a movie that evening, but instead they decided they wanted to climb a nearby mountain. They kept on coming to the teacher and saying, we don't want to watch this. We're out in the mountains. We want to go on a hike. Let me go on a hike. We won't get in any. This is just a hike. We just take us out for a hike. And the teacher initially said no, but people wear you down. And he finally gave in, and he drove them out to the starting point of this trail around 6 p.m. Right? So 6 p.m. in the mountains, right? It's in during school season, so it's starting to get dark, right? Now the teacher, he didn't go with them, and the students weren't dressed properly for the climb. Right? They hadn't brought any water, brought anything to drink. They didn't have flashlights, didn't have watches to, watch their time to make sure that they weren't out too late and then get caught in the dark, where you can't even see. Right, in the nighttime, out in the, how dark that is if you go camping. I mean, you can't see anything. And this student, this 19-year-old student, he fell and hurt himself permanently on a rock face. Right, so in court, it was found that the teacher was liable and hadn't exercised his duty of care, despite the fact that the student was 19. He was an adult. This, in the judge's view, didn't extinguish the student-parent duty of care relationship. So you can see how powerful that student-parent duty of care idea is. It even transcends age, which typically we would think at the age of 19, you're smart enough, you're sensible enough to know that this is not a good idea for me to go out at such and such a time. Here's another one from 1997, Boise v. St. Paul Roman Catholic Separate School District. Here, a 13-year-old grade 8 pupil injured himself making a 7-foot jump in an obstacle course during a movement education class. And this boy was obese, and he wasn't used to big jumps. He told his teacher that he wasn't comfortable with doing it. But it ended up that I don't know if he was pressured, he was told, no, well, to do it, you got to do it, or what happened. But he did it anyway, and he went over this wall, and he hurt himself. And the judge found that the teacher had failed to exert his duty of care, calling the injury foreseeable. If a obese child gets on top of one of those walls and then jumps off, it's foreseeable that, he's going to get hurt. But this is an interesting quote here from the judge's commentary, folks. I'm going to read it to you. Any jump, it doesn't have to be from a height of 7 feet, is potentially dangerous. Careful parents are concerned when their children jump from any appreciable height. Feet were made to walk on a surface, not to fly through the air. I mean, okay, like I get how, maybe the teacher should not have had this child, even after the child said he wasn't comfortable doing it, and, he's kind of a bigger kid. How, maybe he should have said, well, okay, don't do that, but then do this other activity, this other movement activity instead, right? I get that from a 7-foot height, but here, in the opinion of the judge, any jump, like even from 2 feet, is potentially dangerous. This to me, you can see how different judges will rule differently given circumstances or facts. This seems a bit extreme to me. Like, so what does that mean? Does that mean anytime I have students jump that the feet were not meant to, fly through the air, that always the only thing we can do is walk on a surface? What does this mean exactly, right? Like, would a careful parent say no jumping ever, right? Or what are we to make of that, right? So sometimes these court cases, it seems to me, depending on which judge is ruling, they can interpret what a careful parent would like. Is that an overprotective parent? Like, if I never let my own son or my own daughters jump from this distance or that height, or I say jumping is something we don't do because feet aren't meant to fly through the air. Like, okay, well, I guess gymnastics is out. I guess any kind of dance is out. I guess taekwondo is out. So recognize that sometimes judges aren't necessarily, I would say, entirely reasonable in their judgments either. And then these sorts of comments that judges make can be used to kind of kick a hornet's nest for litigation. Maybe more litigation could be built upon a case like this, right? Even though perhaps to have a 13-year-old or a grade 8 pupil jump from a 7-foot height isn't necessarily too dangerous. I mean, I remember crazy distances I jumped when I was a kid. But what about a 6-foot height? What about a 5-foot height? What happened at that school after that? Were kids ever allowed to jump ever again at that school because of this court case? Questions. What about absence of supervision? Brown and Zucker, in their book, say the standard of care expected of educators does not require the presence of a teacher at all times. Okay, so for the teacher's presence to be relevant, it must be shown on evidence that it might have prevented the accident. There must be, in other words, causal connection between the lack of supervision and the accident. So it doesn't mean that every minute of every second of every, that somebody has to be watching, Big Brothers, that's your, no, that's not what you're there to do. I think sometimes it's presented that way, that you can't even step out of the room if you suddenly find yourself having to go to the washroom really badly, right? That, a careful parent would never leave, grade 11 or 12 students alone for a second of their lives. Well, I just step out to use the washroom, or or I'm coughing so badly I just need to go to get, to the fountain out in the hall to get a drink and then come back. Some people would say, well, you're never allowed to do that. Well, come on, is that prudent? Is that the prudent standard of care of a teacher or of a parent, right? Is there a causal connection between you having stepped out or you not having been looking at them every second of the day that this happened, and that's why this happened, and you're responsible for the accident? So here are some court cases about absence of supervision and the causal connection idea. Hill v. Langley School District in 2000. The BC Supreme Court found the school not liable for injuries sustained by a student struck in a school parking lot. All right, so the parents complained that the school didn't meet its duty of care to supervise the parking lot at the end of the day. The board did supervise the entry and the exit to the parking lot, but a street owned by the local municipality had become an extension of the school site simply because the school had grown beyond its property borders. All right, so that happens all the time, right? Like, you've got typically a little lane that runs onto school property where buses park, and then the kids can be picked up there. But sometimes, that gets so full, and there's so many kids that, kids are out on the sidewalk next to the school or adjacent to the school, and the buses pick them up there, or they go from there to somewhere else. It's not school property, but it's municipal property being used and occupied in some fashion by the school, so the school can be held liable to supervise students when they're off campus, technically, or on portions of property that are not school property. So the duty of care does extend beyond school property to include the zone over which school authorities exercise supervision, so also areas next to the school. But the court said that the level of supervision, which in this case was one teacher to 1,200 students, wasn't any good, right? It was simply, that's not enough teachers. Like, you should have more supervision than that. But did this lack of proper supervision cause the accident? Like, was there a causal connection? Because, and they said no. No, the court said that no amount of supervision could have prevented this particular accident. Moreover, the school had previously taken steps to educate its students about traffic safety. So, even though, there wasn't adequate supervision, even in that case, it wasn't found that there was a causal connection between the accident and the lack of supervision. Okay, so keep that in mind, that there has to always be causal connection proven in relation to absence of supervision and an accident that occurs on your watch. Okay, Robinson v. Calgary School District 19 in 1977. Here's one. It's interesting. You tell the kid, don't go down the banister. Stop sliding down the banister. If I catch you sliding down the banister, that's against the rules. Please don't do that. Right? This student had been told, many times not to do this, but went ahead and did it anyway, and surprise, got hurt. And so, what? Like, are you supposed to station somebody at the banister, staring at the banister, watching everybody so that they don't slide down the banister all the time? And if no one's there in the hall or in the stairwell at the time when classes change, and somebody does this and they get hurt, are teachers being negligent? Well, the judge found no liability on the part of teachers or the school, writing that teachers can't provide minute by minute or second by second supervision of students, right? So no causal connection there, and it's unrealistic. In fact, it'd be kind of creepy, wouldn't it, to have a school where every second of every day, in every locale, there's no place to escape the eye of teachers, right? Like, how does that build responsibility, right? So this is an example of how absence of supervision doesn't necessarily mean that somebody's being negligent. Another one, Parks v. School District number 39 in Vancouver. This is 2003. A pupil was injured when hit by a skateboard shot out by a student from a neighboring school who was passing through the school property after the end of the day, but still when supervision by teachers was in effect. So a kid gets hit by a skateboard, right? From a kid from another school who's wandering through school grounds. Parents want to sue. Court finds no liability. Just because you're supervising doesn't mean that every time someone's hurt, it's your fault. Okay? That's an important thing to remember. More cases. The prudent parent standard and supervision. In Ramsden v. Hamilton Board of Education in 1942, so quite an old case, here we have a 16-year-old boy injuring himself by flicking a chisel into a revolving sander. And the judge ruled it was the boy's fault and that the supervision had nothing to do with the injury. Like, I mean, you're there, you're the teacher, you're the shop class teacher, you've told them safety rules, you've showed them how to be safe, but can you be standing over every kid at every time? What if a kid wants to do something dumb, right? One of my daughters, when she was little, she's a real smart kid, but she wanted to know what would happen if she stuck a paper clip in a light socket. I guess I could have went around, and actually we had gone around when they were a lot younger, and put those plugs in all the light sockets, but at a certain point, the kids get older, you don't think that they're going to be up to that. You take those out, and after all, you're always using those things to vacuum, and so they're harm. But you're not looking every minute to find out, to watch, to monitor what children are doing, and sometimes they learn this way. She never did that again. Right? Our house didn't burn down. She got a little burn on her fingers, but this happens, right? So here the judge said, you know what? This is the boy's fault. This is not the supervisor's fault. It had nothing to do with the injury. One would wonder, right? This was 1942. What about if that court case came back today? If would the teacher then be found more liable? Perhaps in today's environment, greater duty of care would be expected. I don't know. Butterworth v. Ottawa, 1940. A 14-year-old boy injured his elbow vaulting a horse in gym class. 2 senior boys had been left in charge and the teacher wasn't present. All right, so teacher took off, maybe he had something that he had to attend to. 2 senior boys were left in charge, and this boy injured his elbow. The judge, 1940, wasn't satisfied that the absence of the teacher had causal connection to the injury. Right? He left these older kids, and they knew, and they'd been through this. Maybe they were trained in gymnastics or something, or maybe they were just older. But he found it was the boy's own fault, knowing he was clumsy and should have spotters, but doing the vault anyway. All right, so this is an interesting one, right? Here you have the judge saying, well, I can't see that necessarily that the teacher not being there caused the injury. If the teacher was there, the kid might still have injured himself vaulting the horse in gym class. In fact, it's the kid's fault for vaulting the horse in gym class, because he knew earlier on, he knew himself, he knew that he was clumsy and should have spotters, but he did the vault anyway without the spotters. Now, I mean, I think that this one today would totally not go in favor of the teacher. It would go against the teacher. I don't think you'd find a judge blaming a child for being clumsy and for knowing that he's clumsy and he should have acted differently knowing that he's clumsy. That probably wouldn't happen anymore. But you can see how much causal connection had to do with proving negligence, teacher negligence in that case. Here's another one, Janagiri Bojani v. North Vancouver in 2001. A student wearing a cast was asked to supervise or just watch fellow students in a woodworking class because he couldn't do the work with his cast on, right? So you're injured, boy, go stand over there and watch as the other kids perform the thing. You sit out this one while your injury heals, right? What happened was another student in the class jammed a piece of wood in a wood jointer. And this student, who was told by the teacher, you're not doing anything today, you're just watching, all right? Just watch. He didn't listen, went and tried to pull out the piece of wood from the joiner and injured his fingers, got them all mangled up in this machine. And it happened, right? So he had no business being anywhere near it. He had no business going in there and grabbing it. He had no business doing any of that. He was told just to watch. The school board was found liable. Why? Well, it didn't have a working guard for the jointer's blade. So that red thing on top of the jointer, apparently that thing wasn't functioning properly, right? And the teacher was found negligent in asking the student to supervise when wearing the cast. Interesting, right? And the student himself was found only 50% liable for disregarding safety rules and instructions. So you can see, right, 2001, so different. The attitude of judges, so different now to back in the 1940s. And here we have another one from 1984, so a bit older. You've got a 17-year-old boy hurting himself on a wood jointer. Similar kind of thing. He'd missed 5 demonstrations on its use, right? The judge found the teacher 50% liable because he failed to provide the student with makeup lessons. So, I guess maybe the kid wasn't around, whether he was sick or suspended or skipping or whatever. The demonstrations had happened 5 times in class. The kid was snuck through. It makes me wonder, right? Like, did the shop teacher, did he not realize that the student had missed all the demonstrations? I mean, it makes you wonder, okay, well, if I'm doing demonstrations of cooking or using a stove or using a particular art supply or using certain chemicals in my chemistry class, and I know, and I'm trying to be dutiful with my class, and I do it 5 times. I do this demonstration 5 times in my class, and I'm constantly reviewing and constantly, I'm trying to be a dutiful teacher, but there's this one kid who somehow managed to miss all 5 times that I've done this demonstration. Like, am I supposed to be bean counting to make sure? Like, do I have to know specifically what happened on any given day when that kid wasn't there? The judge is saying, yeah, man, you have to make sure that you know exactly what the student has missed, what he hasn't missed. Like, maybe how you could get around this nowadays would be to say, okay, well, everybody who's going to try a particular exercise or a particular lab or something like that, maybe what you want to do as a teacher, just to help you keep track of what kids have seen and what they've tried and what they've been instructed on, what they haven't, maybe you want to have like a passport. I've often used passport systems for English and social studies and things like that. So maybe you have something similar like that. Like, in order to try this activity, you have to produce for me a passport that I myself have stamped that lets me know that you've already gone through this and that hurdle and you've had demonstration and instruction on it, that you haven't missed it in some fashion. Then you could have covered your base. Like, it seems to me that the teacher was actually pretty careful, considering that this had been demonstrated 5 times. But nonetheless, it sounds like he didn't have a system like that to make sure that, okay, show me your book. Where's some kind of evidence that you've done this stuff? Because I have so many kids. If I'm the shop teacher, I'm teaching shop to probably 200 kids a day. How do I keep track of who's seen what and who's done what? Even though I'm very careful en masse with my classes. There's a funny part. I don't know if it's off color now to give you a sketch from Bill Cosby, considering all these horrible things that he is said to have done to women. But there's a funny bit from back, before all these charges against him, about shop class, and he's giving a comedic presentation on what it was like in his shop class and how certain teachers can deal with disruptive or stupid behavior on the part of their students. I thought I'd play that for you now.
Junior high school, shop, right? Do you have shop? Oh, I was the worst kid in shop ever, man. Anything I ever tried to make always turned out to be an ashtray. I'd mess it up, put 2 grooves in it. What is it? An ashtray, that's right. Looks like a wet-knot shop to me. I built them like that, put 2 grooves in it. I couldn't even make a shoe shine box, put 2 grooves in it. Well, there's an ashtray there. How come you got polish in it? Well, there's different kinds, Oh, I was the worst, man. And we had a shop teacher that was like a psychology. Well, he had a little touch of psychology. See, in the first place, I went to school with kids that they were on the brink of becoming killers or priests, one way or the other, man. There was no middle of the road, nothing there, And the great part about it was that we were in shop, and this guy, we had gotten rid of 5 shop teachers, and within about 3 months, man. And we had the kind of kids who wear the hat sideways, and they wouldn't stand up straight or nothing.
I've had classes like that.
They had about 12 toothpicks in the mouth, And you'd say, "How are you?" And he said, "What did he say?" He said, "Kill." And somebody found a .45 bullet. We were in a metal shop. And put the bullet, the guy says, "Hey, if you put a bullet in the furnace, it'll explode." That's it. This was the brightest one in our class. So everybody else said, "Close it up." And this one, psych shop teacher, he could always get guys to confess by talking about their parents. He would degrade the parents, and then the kid would get angry.
Don't do that,
and
folks.
We're sitting there, and everybody's tinkering away. Tink, 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 tink. And the bullet is in the furnace, Tink, tink, tink. And then, tink, 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 tink. So here he comes. All right. I put a bullet in the furnace. You put a bullet in the furnace that reflects on your parents. Your mother must be pretty low down for you to put a bullet in the furnace. So now it starts. "Hey, Larry, you guys talking about your mother over there." "Yeah, your mother's got to be pretty low down and right. Listen, I didn't put the bullet in the furnace, and stop talking about my mother."
Oh, so Bill Cosby, it's too bad. He's not out of order really in a discussion of teaching, because one of the lectures I want to give you on education law and you as a teacher is a role model, right? And Bill Cosby, ever since I can remember, he's been such a role model for people, right? Like, he's supposed to be the quintessential excellent father, and he's always seen with children, and he seemed to be loving and compassionate and funny. And he had, when I was a kid, they had, Fat Albert and this cartoon series, and every one of them had this wonderful moral lesson at the end of it about behavior and being thoughtful and kind towards others, and what to do when you catch somebody doing something that's bad, and what the proper way to treat women is, and what is physical and sexual abuse. Like, these things, I don't know. And then like, and it's such hypocrisy. It's such utter hypocrisy for him to have done these horrible things. Not just once, but like, he's a serial rapist, this guy, right? These are the allegations against him. And it seems like the evidence is pretty overwhelming that these things happened. and it just sullies everything with regard to him. And so, I think that's part of it, is just that the expectations around Bill Cosby and him as a role model, right? Him as this successful, like he's one of the fathers of one of the great gods of comedy, and so many people, not just kids, myself and that, but comedians looked up to him, and then to find these things, happened, and that he did these things, and he did them not just in error, but he did them willfully. It's just astonishing. And I think, in some ways, when teachers get up to no good, that we're held to such high account too as role models, right? That we're expected much as, we're not celebrities, but we're expected. Really great behavior is expected from us as teachers. And so, a funny bit from Bill Cosby, but it seems like it's really hard to listen to Bill Cosby anymore. The things that, I used to love to play Bill Cosby for my students and even my own children, and they love Bill Cosby. But I haven't, ever since this happened, I haven't played Cosby. So hopefully you can still find that bit amusing on The Shop Teacher, though. Okay, another court case, Brown v. Essex County, Roman Catholic Separate School Board from 1990. This one is an interesting one, ladies and gentlemen. A student was injured in a grade 8 sewing class. The teacher had demonstrated and instructed sewing activities prior to the day of the accident. Right? So this is not something that wasn't prepared or led up to. Students had practiced on paper, but not on cloth yet. So they'd done sewing practice using paper, but they hadn't moved yet to cloth, see? So there'd been instruction, they'd had kind of a lead-up activity. They also hadn't been instructed specifically about what to do if cloth ever bunched in the mechanism down below where the needle is, and how that can cause a needle to break. If cloth bunches, I've never used a sewing machine, but apparently it can cause a needle to break. They were only told by the teacher to stop immediately. Like if they encountered any problems, if something happened, something was funny, just stop the machine. That's what the teacher said. So, the student was injured when he didn't stop the machine, as the cloth had bunched and the needle broke. And this is what happened. A freak piece of metal, this little shard of this needle, is just a freak accident, flew up and hit him in his right eye, permanently impairing some of his vision. Like, terrible thing to happen, right? Was this accident foreseeable? Now, testimony from sewing teachers and from machine experts all said no. Like, they'd never ever heard of this particular thing ever happening. There's no incidents that they knew of that, if a needle breaks, it could fly up and take your eye out. Never. But the judge nevertheless found the injury foreseeable. Right? So, again, judges can rule pretty differently than what you might expect. He chastised the teacher for only giving a general caution to stop if the machines had problems. He noted that the boy had no background in sewing, right? It was his first ever class. Even though, right, he'd been going through and telling about the machine and how to sew, and they'd been practicing on paper. He had no background. And the judge said that if the teacher had told the kids that a jammed needle could break and fly up and hit them, then the incident could have been avoided. But, again, like the expert testimony was that they'd never heard of that. So, in other words, here, testimony seems to suggest that it wasn't foreseeable that this could ever happen. No one even would ever have predicted. But the judge, nevertheless, found that, the teacher should have known better. The teacher should have predicted that this freakish thing that had never ever happened before could actually happen, and the student could be injured. So different judges, different outcomes. Unfortunately, common law, maybe doesn't always provide enough enough guidance to judges in how to utilize their discretion. I mean, I personally feel like this is a kind of a ridiculous court case. It's terrible what happened to the kid, but is that necessarily? I mean, is it reasonable to say that teacher should have been able to predict that this would happen? Like, is it now the case that in sewing classes everybody must always be wearing eye protection? When you use a sewing machine at home, do you put on eye protection? You know, we put on eye protection in shop class. Is it now the case in a home economics class or in a sewing class that everybody must be wearing eye protection? Maybe that's the outcome of this. I don't know. Plumlee v. North York Board of Education in 2000. A girl's shoulder was injured during her swimming class when an instructional assistant at the pool pulled her partway out of the water by her right arm in an effort to demonstrate a pool rescue technique called resecuring. Medical evidence was reviewed, and the judge found the injury was foreseeable by the assistant who had training and certification. So in other words, what it sounds like to me, right, you've done this, maybe as a student when you were, or you can remember having swimming lessons, right? Your school offers everybody swimming lessons. It's cool. Lots of kids don't get swimming lessons. They can't afford swimming lessons privately, so the school takes everybody swimming. You sign forms. You go swimming. You have the day. But it's not your teacher. I mean, maybe, but I've never experienced that where it's actually the in-class teacher who is the swimming instructor. No, you go to this public swimming pool and they have certified swimming instructors there who teach you safety, who teach you, swim strokes and the rest of it. This was the case here, right? You had a swimming instructor who pulled one of the students out of the pool and injured her in the process, right? Injured her shoulder. But the classroom teacher was also found liable in this case for lack of instruction. So even though the classroom teacher was not in the pool, wasn't any kind of expert in, swimming or anything, and that's why they handed it over to the swimming instructor, the classroom instructor was nonetheless found negligent for the actions of the swim instructor who had the expertise. Why? Well, for failing to have the pool instructor or assistant advise students about safety in this situation. The school was also found vicariously liable. So you can see just how much the new attitude towards teacher liability, school liability, seems to have swung towards, yeah, man, you better watch out, because it's more likely now that teachers are going to be found liable for things that they never before would have been found liable. And not only them, but vicariously liable school boards. And then there's really big money to be had there. If you can get a school board to be liable for an injury or some kind of suffering, there's big money there that can be drawn from an injury. These are the last things I want to talk about with you in this particular lecture, folks. This being Calgary, we've had over the past 10-15 years a number of pretty horrible field trip tragedies, and these field trip accidents have kind of shaken things up. So now, like, often I've heard it, teachers say, well, it's so hard to organize a field trip now. There's so much forms, there's so many safety mechanisms, there are all these waivers now, there's so much liability. Very often now you hear them talk about how you just can't be bothered anymore. But here's an example of a field trip tragedy from 2000. This is reported by CBC News. Crisis counselors spent the beginning of spring break at a Calgary high school trying to console parents, teachers, and students after a school trip ended in tragedy on the weekend. It happened on the Lost Coast Trail in Northern California. A group of 27 students, parents, and teachers from William Aberhart High School. That's where my eldest daughter just finished high school. They were all on a hiking trip. They were walking on the beach when one of the parents, Barbara Clement, was swept away by a rogue wave. So they had, parent supervisors, right, as part of safety, and the parent supervisor was swept away by a rogue wave. The two students, right, courageous young kids, they tried to save her, but they were drowned too. Another student and teacher jumped in to save them. They were later rescued. And from his hospital bed, teacher Martin Poirier said, "I saw the two kids were in trouble with the mom, so I took off my pack and went and tried to help them, but even before I could reach them, there were two waves on both sides of me, and it just caught me and I ended up in the ocean." And Barbara Clement was 45. Her body was found Sunday by search crews. The students were David Elton and Brody McDonald. Both of them were 17. And while their bodies have not been found, they're presumed drowned. The other students have returned to Calgary. Jack Crawford, whose daughter was on the trip, says it's the type of phone call no parent ever wants to get. At a news conference on Monday, Crawford says he spoke on behalf of other parents in thanking the students and teacher who tried to save their friends. Crawford also says parents hope this accident will not affect similar trips in the future. The biggest tragedy that can come out of this event is if other students are denied the opportunity to participate in similar educational experiences, says Crawford. Really horrible, horrible accident, right? But I mean, is is such an accident preventable, right? Like, I mean, one wonders, right? Like with a trip like that along the Lost Coast Trail, is it well known that is this a common occurrence that there are these rogue waves? I mean, I guess a rogue wave means it's kind of a freaky thing, right? But how safe is this, and how much danger are you entitled or is allowable, or threat of danger is allowable or permissible in organization of a school trip? Here's further to that court case, or further to that particular accident, what the Calgary Board's response was. The Calgary Public School Board says it was not to blame for the tragic school field trip that claimed 3 lives last March. In a report, so it says this wasn't our fault. In a report released on Monday, the board did not accept responsibility for the drownings, but it did promise to ensure more precautions are taken on future field trips. "We're not responsible for an accident that may have occurred," said Donna Michaels, Chief Superintendent with the Calgary Board of Education. The board says it will do thorough risk assessments of future field trips. It will also set up a program to monitor school trips. Hazel Kochel, mother of one of the boys who was drowned, says she is glad that the board has taken some responsibility and addressed some issues. She's still left with questions about why the area wasn't more thoroughly checked and the hikers more prepared. See, so even though, she has serious problems with, some of the, I guess she would say that to a certain extent, the board is absconding upon some of its responsibilities towards these young kids who were killed. Koschel now wants the board to act on its recommendations. "I want to make sure," she says, that no other children die. A bunch of words in a binder don't make sure children don't die. Action makes sure children don't die, she says. "We will take these recommendations into serious consideration, but none of us can guarantee ever, anywhere, under any circumstances, accidents will not happen," says Donna Michaels. All right, so that's very true. Accidents always happen. There's no way of keeping people secure from all dangers. Sometimes there is danger and risk that's higher or lower. So what's the threshold for these things, right? Was there some foreseeable or predictable element in this particular hike that the kids did that should have put up red flags for people? Should there have been more training on what to do? Like, what could have happened? Like, even if there were more training, would that have solved any of the difficulties? Here's another example of a school trip that ended in tragedy right around the very same time. Like, this one was in Edmonton, though. Edmonton, for those of you who are not from Canada, it's a city about 4 hours north of Calgary, in Alberta. So an end of school outing ended in tragedy Wednesday when 13-year-old Nazim Kasim drowned in a lake. Kasim was on a field trip with 120 of his classmates from Dickensfield Junior High School in Edmonton when the tragedy occurred. RCMP, that's the police up here, say the boy was swimming with a group of other students when he got into trouble and slipped under the water. Teachers, parent chaperones, and lifeguards were at the scene at the time. All right, so it's not like there wasn't enough supervision. The accident was has made many teachers like Colleen Woloshin uneasy. It's very sad, very tragic, she says. I think it's going to be on the mind of every teacher in the city today. Woloshin was even more cautious than usual on Thursday as she took her students swimming in a city pool. It made me rather nervous. I thought about it, and I talked to the kids in the classroom this morning about swimming with a buddy. She said the drowning on Wednesday was the latest in a series of school trip accidents. Edmonton's Public School Board is now reviewing its school field trip policy. All right, so these sorts of, accidents, like, they're horrible, horrible things. And there's questions about, teacher liability, school liability, negligence, how to make things safe. What element, what aspect, how much danger is allowed? What would a prudent parent do? Do prudent parents take their kids on field, on trips into the woods? I mean, I go all the time with my kids into the woods. We don't go backcountry skiing, things like that. But, we go down by the water. I've taken the kids, so what is the level of, or duty of care that's demanded here? This was a horrible one. 3 years later, a local school here, it's a prestigious private school in the south of Calgary, it's called Strathcona Tweedsmuir. On February 1st, 2003, a group of teens from Strathcona Tweedsmuir were on a backcountry field trip when disaster struck. The teens were part of a group of 14 grade 10 students and 3 adults that were swept up by a huge snowslide in the Connaught Creek Valley just west of Rogers Pass. That season, 29 people died in avalanches. All right, so you wonder, right? Like, well, okay, this is avalanche territory. 29 people died this year in avalanches. I don't know if that number includes these students, or if it's even apart from them. But I mean, shouldn't that be some kind of an indication that this is not a good spot to go with students? I mean, I would never even take my own. See, my particular feeling is I would never do that. As a parent, I would never take my kids into such a place. But in Alberta, we have lots and lots and lots and lots of people who go skiing, they go snowboarding, they go skidoo riding out in these areas, and many people every year die in avalanche areas. A series of reports were later drafted and sometimes criticized, but there have been real changes in how authorities, school, and recreationists treat the winter backcountry. Family of several Strathcona Tweedsmuir victims have since acknowledged they are pleased with the major progress made in the past decade. So this tragedy, one of the things that it did do was it got people talking about the dangers of these avalanche areas, right? And how, we need better monitoring systems, and how, people should be more informed, and how there should be greater responsibility about going in places like that. Like, it's terrible what happened, but then, like, the parents are saying, well, in other people, I guess, if you could ever find a silver lining in such an ugly thing, that one of the things that it did do was it brought this issue right to the forefront of public consciousness, which is good, right? Ross Cloutier, an expert on outdoor education, was hired to author a study on Strathcona Tweedmere School's outdoor education program. He produced a 58-page report that spurred schools nationwide to examine their policies. This was the biggest ever event that forced schools to sit up and take a look at what they were doing, said Cloutier, a professor in the Adventure Studies Department at Thompson Rivers University in Kamloops. Terrible things have happened, folks, and to students under your care and supervision. Let's not be ever negligent. Let's exercise our duty of care. Let's be, as much as we're able, prudent, caring teachers and standing in loco parentis or in place of the parent. Let's try to be reasonable in our considerations of their safety. Okay, that's the end of that lecture on negligence and duty of care. The next one that I'm going to lead you through concerns parental harassment and the bullying of teachers. Thanks for your time.